It is the policy of the Idaho Supreme Court to ensure access to the courts to all people, including those who may not have the benefit of legal representation. The purpose of the Court Assistance Office in your county is to provide self-represented litigants with educational material, court-approved forms, limited assistance completing those forms, and information about the court procedures so they might better understand the legal requirements of the court system. Instructions you receive in a court assistance office or from a court assistance officer are not a substitute for legal advice. The laws and court rules are complex, and following these instructions will not guarantee you a favorable result. We always recommend you talk to a lawyer about your specific case before filing your paperwork. If you cannot afford to hire an attorney to represent you, you may be able to pay a lawyer to give you advice and review your paperwork for a lesser cost. You may contact the Idaho State Bar Lawyer Referral Service for the name of an attorney in your area who will provide an initial half-hour consultation for $35. Contact the Court Assistance Office for information about resources for low-income people or visit the Idaho Supreme Court's Self-Help Center online. Self-represented litigants are encouraged to seek a consultation with an attorney if at all possible. All Court Assistance Office forms are available online for free or can be purchased pre-printed at the courthouse for a fee. Once you have obtained your forms, you may begin filling them out. The first thing you will want to identify is the form that you are working with. You will be able to find the title of your form on the first page right under the case number, and also at the bottom of every page of the form in the footer. When preparing a legal filing, the party who will be filing the document is identified in the upper left-hand corner of the document. It is very important that this information is up to date and accurate. Any correspondence sent to you from the court or the other party will be sent to this address through the mail or email. These forms are for use in any of the 7 judicial districts in Idaho. When you file your form, be sure to identify the district and county where you will be filing. If you are opening a case from the beginning, you are the petitioner and the other party is the respondent. You will be given a case number when you pay your filing fee. Once the case number and the original order of the names are established, they will never change. This is like the thumbprint or identity of the case. In common family law filings like divorce, custody, and modifying previous child support and custodial orders, we can use this simple diagram to explain the court process from start to finish in 3 easy steps. The first step is filing. The second step is serving the other party with a copy of what you filed. And the third step is finalizing, waiting the 21-day mandatory waiting period, and then submitting all the finalizing paperwork to the judge to get a signed court order. Let's discuss step 1, preparing and filing your petition. To begin your case, the first thing you need to do is get all your forms. All Court Assistance Office forms are available online for free or can be purchased pre-printed at the courthouse for a fee. Next, you need to access Court Assistance Office instructions and resources provided with each form to learn how to fill them out. Your county may offer a Court Assistance Office Family Law Forms workshop that you're required to attend before filing. Once the forms are filled out, you can make an appointment with your local Court Assistance Officer for a form review. Please note, the Court Assistance Officer is not permitted to review blank forms. After your forms have been reviewed and approved for filing by the Court Assistance Officer, you must make copies for each party involved in the case. Then you may proceed to the clerk's office to pay your filing fee and file. At the time of filing, the deputy clerk will issue some mandatory court orders based on your type of case. Please read these orders. They are very important. The first is an order to attend a co-parenting class called Focus on the Children. You will be assigned a date and time to attend. The cost is $35 per party. The other two orders are joint prohibitive orders. This means both parties are ordered by the court to follow certain rules relating to shared children and property while these matters are pending. You must read these orders and comply to avoid being found in contempt. If you have any questions, please ask the clerk or the court assistance officer. When the clerk has processed all of your paperwork, he or she will then hand you back two separate sets of copies. One set of copies is for you to retain for your records, and the other set is for you to serve to the other party. At this point, you have just transitioned from Step 1 to Step 2. Step 2 is serving the other party with a copy of what you filed. After you have filed your petition and summons, and all mandatory court orders have been issued, it is your responsibility to prove to the court that the other party has been properly served with copies of those documents. In the state of Idaho, there are 3 different ways you can accomplish this. The first is by using a form called an acknowledgement of service. This form would be signed by the other party in front of a notary, acknowledging they received the paperwork on a specific day. The second option available is using a form called an affidavit of service. This document would be signed by an uninterested party, 18 years or older, who would personally hand the documents to the other party and then sign the affidavit certifying that they did so. This document does not need to be notarized. You may choose to pay the sheriff or a professional process server to serve the other party for you. If you do not know where the other party is, service by publication is the final acceptable form of service. This process involves requesting permission from the judge to publish your summons in the newspaper that publishes legal notices in the area of the other party's last known address. Service by publication can be very expensive depending on where you need to publish, and will add at least 6 weeks to your case time. Please contact the court assistance officer directly for more information. Once you know what day the other party was served, you will begin counting the 21-day mandatory waiting period, starting the day after they were served. This is the time afforded to the other party to read over the petition you filed and decide whether or not they want to contest to anything you asked for in your petition. While you are waiting those 21 days, it's a good idea to begin completing all the Step 3 finalizing paperwork. Once you know what day the other party was served, you are ready to begin Step 3. Step 3 involves waiting the mandatory 21-day waiting period and preparing the finalizing paperwork. On the 22nd day, if no response has been filed, you may submit your final paperwork for the judge's ruling. As an alternate Step 3, let's discuss what happens if the other party files a response. The first thing you need to do is not panic and do not get upset. This is the other party's right to file a response, just like it is your right to file a petition. This is a court system, and all citizens are offered equal access to the resources available here. It should be noted the court assistance officer may provide assistance to both parties and does not favor either party. A court assistance officer will share all available court forms and resources with both sides. Next, you will need to identify whether the other party filed a response or a response and counterclaim. In a response form, the other party would state what they agree and disagree with in your petition. In a response and counterclaim form, the other party would state what they agree and disagree with in your petition and then proceed to outline what they want in the same way you did in your petition. This would include their requests regarding child custody, child support, and property division. If the other party files a counterclaim, you are then required to respond to the counterclaim within 21 days. Once any type of response is filed, both parties are required to submit mandatory child support disclosures to each other. This will include an affidavit of income and your income information for the past 2 years. Your case will then be set for what is called a scheduling conference in front of the judge. This initial hearing will be a brief 10 to 15 minute hearing where all parties are informed of the scheduled trial date. The judge will also have the opportunity to order the parties to participate in a form of alternative dispute resolution, which may include mediation. If a response is filed in your case, please contact the court assistance officer as soon as possible to obtain forms and detailed instructions explaining the next steps.